To keep everybody on time, thank you. So if you would please take your seats. Good morning to all, and welcome to the third and final panel for today of our conference. My name is Olya Antle. I am an attorney with Cooley LLP in Washington, D.C. It is my sincere pleasure and honor to be here to moderate this panel with these wonderful experts to whom I would like to introduce you to them. Immediately to my left is Katharina Crinson. Katharina is with Freshfields in London. Next to Katharina is Dario Oscos. Dario is the managing partner of Oscos Abogados in Mexico City. And next to Dario is Sergio Savi. And Sergio is the head of the restructuring group at BMA in Brazil. Also on our panel is Mahesh Uttamchandani with the World Bank. Unfortunately, Mahesh could not be here today in person, but we do have a video recording of his presentation, for which we're very thankful. So we will start with the video, and before we start, I just wanted to say thank you so much to the organizers of this conference, Evan, to III, to UNCITRAL, of course to all of the panelists and our hosts, Judge Glenn, the Bankruptcy Court, thank you very much. Our panel will be very much an extension of the thoughts and insights that you've heard today already, but we do look forward to discussing some additional ideas and insights of the panelists. So without further delay, let us start with the video from Mahesh, and then we'll move on to the discussions here.
Hi, everyone. My name is Mahesh Uttamchandani from the World Bank, and it's a great pleasure to be able to speak to you about the model law on cross-border insolvency today. Before I do that, I want to thank our panel chair, Olya Antle, and our hosts at UNCITRAL and the III. I'll speak briefly about the current state of the implementation of the model law, then consider its economic benefits and the need for strong institutional capacity to complement the adoption of the model law. Driving uptake of the model law has been and remains a key part of the technical assistance that we at the World Bank provide to our client countries. Since the model law was first adopted by the United Nations in 1997, it has expanded to be adopted in many countries. The latest data published by UNCITRAL indicate that there's been notification of 57 states in 60 jurisdictions that have enacted legislation based on the model law. These statistics probably also underrepresent the influence of the model law, since many more countries than are included in the figure that I mentioned have to move towards having a law that is closer to the model law, for example, by adopting the model law with reservations or adaptations. The model law also is present on every continent of the world, but overrepresented in the Americas and Africa, and probably underrepresented in Asia and Europe. Some key economies have not adopted the model law, including India, China, and large parts of Europe. The model law has been more commonly adopted in common law than in civil law countries. However, this may be changing, with Brazil and Saudi Arabia adopting the model law post-COVID in 2021 and 2022, respectively. Other recent adopters include Myanmar and Ghana, both in 2020. The model law, which of course primarily focuses on cross-border insolvency, has been complemented in recent years by the model law on recognition and enforcement of insolvency-related judgments, which was adopted in 2018. The object of that second model law is to assist states to equip their laws with a framework of provisions for recognizing and enforcing insolvency-related judgments that will facilitate the conduct of cross-border insolvency proceedings and complement the model law on cross-border insolvency. So far, no countries have adopted the model law on the enforcement of insolvency judgments. However, the UK Insolvency Service has published in July 2022 a consultation paper proposing the implementation of the model law on the recognition and enforcement of insolvency judgments, together with the model law on enterprise group insolvency that other countries may follow. Now, turning to the economic benefits of the model law. As part of the advocacy in support of adoption of the model law on cross-border insolvency and related model legislation, those of us who advise policymakers continue to advocate for the adoption by articulating the economic benefits of these laws. The impacts of good insolvency systems generally are clearly established in the literature and can be conceptually divided into two parts. The first part deals with financial crisis. The way in which an insolvency framework assists in this regard is in managing and reducing high rates of non-performing loans, and thereby enabling a more efficient management and resolution of financial crises. The second part is the broader benefits to the economy that matter both in a crisis context and more generally. There is substantial economic literature on the importance of insolvency as a means to minimize the inefficiency that arises in the absence of an insolvency framework when there are multiple creditors seeking to recover debts unilaterally. In addition to this, empirical research shows that improvements in insolvency systems are associated with greater access to credit, improved creditor recovery, strengthened job preservation, higher productivity, and lower failure rates for small businesses. Now, turning more specifically to the economic benefits of the model law, one can make the following observations. One of the original purposes of the model law was to facilitate investment. Facilitating investment is a stated purpose of the model law, and in fact, the preamble to the model law lists 5 objectives, one of which is greater legal certainty for trade and investment. Now, there's been only limited study of the relationship between adoption of the model law and cross-border trade or investment. A 2008 study examined the economic impacts of the model law in considering whether it should be introduced by Brazil. The study found that the mechanisms of the model law can significantly reduce the cost of transactions by producing, first, better credit recovery, efficiency, and fairness to creditors. Second, a significant decrease in the time needed for the recognition and enforcement of foreign decisions. And third, efficiency of liquidation and restructuring plans with international features and thus maximization of asset value. A 2011 empirical and comparative study by Jay Westbrook and the European Business Organization Review found that the model law does, in practice, have the potential of facilitating unified and centralized insolvency proceedings. In effect, the model law does what it says on the tin, as they say, with the expected consequence of reducing wasted costs and improving creditor recovery. In Singapore's decision-making process around implementing the model law, a 2013 report by its Insolvency Law Review Committee concluded as follows. The increased certainty and cooperation that the model law would generate will in many cases lead to a greater predictability of process and outcome, which in many cases may possibly help lower the risks and costs of international financing, reduce the overall cost of insolvency litigation, and reduce the overall costs of obtaining recoveries or dividends from the cross-border insolvency process. It may also influence foreign investment in Singapore favorably. Turning now to the question of emerging market and developing economy reform. In pursuit of these economic gains that insolvency reforms, including the model law, can bring, there has been a substantial amount of insolvency law reform in emerging and developing economies in the last 10 years, particularly in sub-Saharan Africa. Ghana, Ethiopia, and Mauritius are notable examples, with Mauritius's insolvency law in particular emerging as a model for other countries in the region. Particularly relevant to the model law, in the 2016 reform, Mauritius had a modified version of the model law, including a reciprocity requirement that both countries abide by an agreement for the mutual recognition of insolvency proceedings. That reciprocity requirement under the previous law had led to a significant increase in time and cost in the recognition process because practitioners reportedly needed to obtain formal translations and notarized documents. Mauritius has now removed the reciprocity requirement. These admirable reforms have unfortunately had little measurable impact when it comes to the recovery rate for creditors. In sub-Saharan Africa, for example, the World Bank's Doing Business data in 2011 showed an average recovery rate for sub-Saharan Africa of 23.2 cents on the dollar in an insolvency proceeding. In 2020, according to the same indicator, recovery rates in the region had actually gone down to about 20.5%. An important explanation for this is that many emerging and developing economies lack the institutional capacity to effectively implement these new laws, so the laws are not being used to their full effect in practice. Insolvency filings remain low in many of these jurisdictions, and instances of restructuring and company rescue are indeed rare. Thinking about institutional capacity, one notices that the key components of this capacity are, first, the competency and organization of the court system. For example, having judges that specialize in commercial or insolvency cases. Second, insolvency practitioners having a sufficient standard of competence and ethics and being appropriately regulated. And third, creditors that understand the benefit of collective insolvency procedures and are willing to engage with the insolvency system as opposed to only ever seeking piecemeal and unilateral enforcement of debts outside of a collective insolvency process. In the absence of this institutional capacity, it might be concluded that mere adoption of the model law is not a good idea for many emerging markets and developing economies, as it needs to be supported by institutional capacity improvements, in particular insolvency practitioners and courts familiar with the operation of the model law. I'll give but one brief example. Without institutional capacity, companies centered in an emerging market and developing economy that have adopted the model law may be disadvantaged by the center of main interest test, because that test would require that the main insolvency proceedings go ahead in the emerging market jurisdiction, even if that jurisdiction lacks the institutional competency to effectively manage the case. This is why, when in the course of providing technical assistance for insolvency reform, one must think of the introduction of the model law as being recommended in the context of a wholesale modernization of the domestic insolvency law and extensive capacity building. In other words, the model law is not the end, it is only the beginning of insolvency reform. Thank you very much, and I wish I could join you in person today, but wish you a fantastic educational program.
Thank you to Mahesh again and the World Bank for this wonderful presentation. So, Katharina, let's turn to you. We have heard from Mahesh with respect to the adoption of MLCBI in over 57 states, 60 jurisdictions across the globe. As we've stated several times today and heard today thus far, none of the countries have adopted the judgments model law. And so if a state is considering the adoption and implementation of the judgments model law, how may the judgments model law fit within that state's insolvency regime?
So it won't surprise you that being a lawyer, my answer is, first of all, it depends. Why does it all depend? So how the judgments model law, and I'll use the terminology original model law and judgments model law because I get myself very muddled up with the acronyms. So how does a judgment model law fit into an existing insolvency regime depends on a number of things, two things in particular. One, whether a country has already adopted the original model law, and of course what a particular country's cross-border insolvency regime that domestically already provides for. So if we look at both of those, I don't only need to know in order to assess how the judgment model law fits into a state's existing insolvency regime, whether it has adopted the original model law, but also how it's adopted it and how it's been interpreted. And here we've heard quite a lot already today that there is large divergence between those countries who have adopted the original model law in the interpretation. So, for example, if you come from a country that has adopted the original model law quite broadly, say, as we heard from Deborah, the USA, or as we heard from Singapore, then you might come to the conclusion that the judgments model law doesn't need to fit in the domestic system because essentially it's already there. Now, if you come from a country, say, for example, the UK, where the original model law has been interpreted quite differently, then the question does arise more starkly, how does the judgment model law fit into the domestic system? Because there is a need to provide a fit. So we've heard from Irit, we've heard from Mark, who is at the heart of all of this, that the UK, for example, has already started a consultation as to how the judgment model law would fit into the UK domestic system. And while the answer is not out, Mark tells us, I think that it is pretty close. So we are all watching that. Now, I said, in some regards, if you are from a country that has adopted the original model law and has interpreted it quite broadly, you might say there's no need for a fit for the judgments model law because in substance, the matter is already covered. And I think we heard from previous panels that there might still be quite a few reasons why you would nonetheless wish to adopt the judgments model law. Be that, I think, as we heard from Deborah, that it's cost efficient, maybe. Instead of having a system where you've got to have your whole insolvency proceedings recognised, it might be far cheaper to just have a debt collection mechanism, a simple insolvency judgment recognised. It might also be that you have different reasons. For example, the judgment model law provides as the basis that there is the basis is you ought to recognise, rather than the original model law, where the basis is you may recognise. So, as a practitioner, I might well choose a system that gives me the basis of you shall, because the evidential burden is a different test than a system that says you may. So there are different reasons why even a country where in substance possibly there's no need for domestic fit for the judgments model law, that country might still wish to actually look at a domestic fit. But the issue, of course, is starkest for those countries that either have not adopted any of the model laws or that have adopted the original model law, but in a more restrictive way.
Yes. So I definitely agree with you. And coming from the UK, how do you view the judgments model law and that fit? And I know that has been covered in some length today, but your personal view as well.
Well, given that our panel is between us and some daylight and some lunch, you'll be pleased that we have already covered quite a few of those grounds. So we have, in this recent consultation on whether to adopt the judgment model law, seen the very tension of internationalism and territorialism. And also that in the UK, I think as Howard said, we have lost so much with the loss of the EU regulation. We do want to be international. We want to be seen to have the international outlook. We want to promote that outlook. On the other hand, of course, and again, with my practitioner hat on, we don't want to upset the apple cart. And we've heard quite a lot on what this very specific British apple cart is, namely the ruling Gibbs and the Supreme Court decision in Rubin. And I don't think I now need to remind the audience what both of them are. People are well aware. And Howard didn't get any boos, so I hope I'm not coming out with a boo on the Pantom villain and the rule of Gibbs either. But they are the two fundamental issues for the UK domestic system that would need to be squared in the judgments model law. And adoption of the judgments model law, whether you do it wholesale or whether you do it through the Article X mechanism, certainly has the potential to override the ruling Gibbs. And you might say, well, that of course was the whole point, as we've heard from Irit, in coming up with the judgments model law, to fill the gap that was identified in Rubin and Gibbs. So where all other elements required for recognition are satisfied, and quite importantly, and I think we've heard this from Rodrigo before, none of the, I think you mentioned it, 8 grounds of refusal to recognise the judgments are made out, then an insolvency-related judgment would be able to be recognised mandatorily if you go the whole judgments model law route or in discretion under Article X, and therefore override the ruling Gibbs. So we would be in a position where, for example, a Chapter 11 debt discharge would be capable of being recognised in the UK where the debt that was compromised in the Chapter 11 was English law governed. So it would provide that potential. Now, a lot would therefore still ride on the grounds for refusal to recognise, and there are quite a few, as I say, as Rodrigo has mentioned. In particular, on one of the grounds, on adequate protection. So, if the UK didn't want to be quite so radical and overrule Gibbs wholesale, and it comes as no surprise, there are quite divergent positions on the ruling Gibbs, and quite a large industry body in favour of retaining the ruling Gibbs. So the question is, can we somehow squeeze the round into the square? Can we adopt the judgments model law while preserving the ruling gives? And there are two questions to this. One, can you actually do it? And the second, possibly bigger point is there a point in doing so? But on the first, can you do it? I think that is where the consultation came from. We do want to adopt Article X, so recognition is possible, recognition is discretionary, but the government did state their intention not to override, at this point, the ruling gives. And that does put a great pressure on the courts and the existing safeguards in the original model law as to whether a judge then would use her discretion to actually override the ruling gives. Where they could, with the Article X mechanism, do so. And if you look at the concept of adequate protection, it might be quite tricky because it would be very difficult for a UK judge to conclude, for example, that if a debt discharge of English law governed law was implemented in a US Chapter 11, there was no adequate protection because the law was governed by English law. That is very political, quite problematic. So it is tricky to fit whether the Article X mechanism or the entire judgments model law into the current UK domestic system whilst retaining the ruling gives. So what that all, in a long, convoluted way, comes back down to is that maybe, using the terms from the EU Observer yesterday, although in a different context, maybe now the time has come for the UK to have that political debate as to what to do with the ruling gives. Because just squaring the ruling gives with the judgments model law is very complicated. So before the domestic fit for the judgments model law can really be determined, it presupposes that policy discussion as to what does the UK actually want to do with the ruling gives.
Thank you, Kat. Dario, turning to you, I was hoping you could address how the judgments model law may fit in a civil law jurisdiction, the one that has adopted MLCBI, especially, for instance, Mexico.
Yes, thank you very much. I'm very fortunate. I have the privilege and the honor to participate in this 5th conference on the anniversary of the model law on recognition and enforcement of insolvency-related judgments that has a great interest of everybody in the insolvency field. And from a civil law perspective, I would say that before adopting the model law on cross-border insolvency, some civil law jurisdictions subject recognition of foreign insolvency judgments to the domestic insolvency standards, on the one hand. On the other hand, recognition and enforcement of insolvency foreign judgments was governed by the general regime on foreign judgments on civil and commercial matters. With the adoption of the model law on cross-border insolvency, incorporated as domestic law, new mechanism for recognition was creating, focusing on the recognition of foreign insolvency proceedings rather than on individual insolvency judgments. This model law on cross-border insolvency provides for a greater scope. It provides recognition of insolvency proceedings as well as individual insolvency-related judgments. I know that a gap has been discussed, and we have this precedent of the Rubin case from UK. However, some civil law jurisdictions that have applied the model law are of the opinion that insolvency-related judgments are within the scope of the model law on cross-border insolvency. Some decisions have been already hold this, and this opinion is based on the interpretation that the model law covers insolvency-related judgments based upon interpretation of a functional provisions and final interpretation of the model law on cross-border insolvency pursuant to Articles 7 of the model law that provides the grant of additional assistance under other laws, Article 21 that has been invoked several times, that upon recognition, the court may grant any additional relief available, and Article 26 of the model law that provides that the court shall cooperate and assist to the maximum extent possible. This provision captures the purpose of the model law, which is incentivize regimes, legislators, practitioners, and courts to recognize foreign insolvency proceedings, to provide and coordinate with legal assistance in cross-border scenarios. This scope of the model law that I have just referred to may be characterized as the umbrella recognition, where the insolvency proceeding is recognized as a cooking pot, the continent, meaning the insolvency proceeding as a whole, and the content, meaning the insolvency judgments. This was precisely the characterization in the IFS Financial Corporation case, where its U.S. bankruptcy proceeding was recognized in Mexico under the model law on cross-border insolvency, which is our Title 12, U.S. Chapter 15. Several U.S. adversary judgments were rendered by the U.S. bankruptcy judge within the IFS bankruptcy proceeding in the United States regarding Mexicans, both individuals and legal entities with domicile and property in Mexico. The adversary judgments were included by the issue of the cross-border insolvency within the umbrella recognition. There was no need for a new recognition. The judgments were already recognized and enforced in Mexico. But you may ask yourself, were those judgments recognized automatically by virtue of law? Well, we have the umbrella scope that recognizes the foreign bankruptcy proceeding as a whole. And within that proceeding, there were more than 150 adversary judgments rendered by the U.S. Bankruptcy Court. So we had them recognized and enforced in Mexico. But for each one, we had to apply in a supplementary way the Mexican law, the general rules on recognition and enforcement of civil and commercial judgments. But in those regards, that was not conflicting with the basic fundamentals of the model law. We took advantage of the model law provisions and were able to have recognized in Mexico this final adversary judgment coming from the U.S. bankruptcy proceeding. And I would say that we are of the opinion that there is no need to supplement the model law, the original model law, with the model law on the recognition and enforcement of insolvency-related judgments. But I think that both laws do not conflict each other. On the contrary, they complement each other. They make a precision of the regulations as to how best to recognize and enforce insolvency-related judgments and the grounds to refuse them. As a special law, without the need to go to a supplementary law in the domestic regime, as it happens today. We will say that by having this interpretation of the umbrella recognition, by having recognized the insolvency proceeding as a whole, as a part, as a continent, it will be easier and faster to recognize or to have recognized insolvency-related judgments and enforce. And what is most important, why I need to have individual insolvency judgment recognized is because I need to collect. I need to have legal tools to discover assets and recover assets. And by having the recognition of the insolvency proceeding, I have access to all the tools provided for under the model law on cross-border insolvency. But if we had to add, to complement this law with the insolvency judgments, I would say that it will be much more better. In fact, I think that by having both laws integrated, as the UNCITRAL Secretariat has already done with this integration of the three model laws on cross-border insolvency, insolvency-related judgments, and the group of companies, we will have a much better tool, legal tool, to facilitate the cross-border coordination and efficiency, and which is most important, to achieve the goals of the model laws that you are well familiar with them. One, cooperation in cross-border insolvency. Second, greater legal certainty to trade and investment. Fair and efficient administration in cross-border insolvencies that protects the interests of all creditors and other interested persons, including the debtor. Protection and maximization of the value of the debtor's assets. Facilitation of the rescue of financially troubled businesses, thereby protecting investment and preserving employment, just aligned with the purposes of the international organizations such as the World Bank and the IMF. Thank you.
Thank you very much, Dario. Sergio, before we discuss the possibility of adopting the judgments model law in Brazil, I wanted to ask you to tell us more about the new framework for cross-border insolvency cases in Brazil. I know that after 15 years since its enactment, the Brazilian Bankruptcy Code has been recently modified in some significant ways. So I was hoping you could tell us a little bit more about the new system.
Yeah, sure. Well, morning, everyone. First, I'd like to thank III and Evan for the invitation. It's an honor to be here, and it's a special event celebrating UNCITRAL's model laws on cross-border insolvency. As Olya mentioned, yes, Brazil just passed a new amendment to our bankruptcy law, and it was really improved in several ways, and one of those ways was by adopting the model law with a few tweaks, and I will comment some of them in a second. The new framework for cross-border insolvency does provide us with all the tools to achieve the purpose of the model laws that you just mentioned, all of them. So now we have rules on direct access of foreign representatives to our courts, method and requirements for recognition of foreign main and non-main proceedings in our jurisdiction, authorization for the debtor and its representatives to act in other countries, methods of communication and cooperation between courts in different jurisdictions, and rules for concurrent proceedings. Now I'd like to turn to some specific aspects of the model law as we incorporated. The first thing is that when we were dealing with the public policy exemption, our legislator used the word manifestly contrary. And this is a very good thing. It says that the Brazilian courts can only refuse to act based on the model law if the action itself is manifestly contrary to Brazilian public policy. And this is in the same way as the main purpose of the model law. There's one provision that is not good. The Brazilian legislator included a paragraph 5 in section 167A, saying that the public prosecutor's office has to intervene in all cross-border insolvency cases. I believe this is wrong. This was not necessary, and is even contrary to our original bankruptcy law structure. During the enactment of our bankruptcy law back in 2005, we even had a provision granting full powers, a lot of powers to the public prosecutor's office, but that specific provision was subject to a veto. I really hope that when Brazilian courts apply the model law in Brazil, they read these provisions very narrow, in a very narrow way. We already had a case, you may be aware, but the Brazilian airline LATAM filed a Chapter 11 here in the United States, and based on those provisions, the public prosecutor's office in São Paulo tried to open an ancillary case there, but I'm happy to let you know that the bankruptcy court in São Paulo rejected such attempt, and the Court of Appeals in São Paulo confirmed that ruling, which is very good, limiting the powers of the public prosecutor's office. Another difference in our rules as adopted is in the definition of the foreign non-main proceeding. According to our version of the model law, a foreign non-main proceeding may take place in a jurisdiction where the debtor has establishment, and this is the concept used by the model law, but our legislator went a little bit further and included the wording or assets, therefore lowering the standards for initiating or recognizing another foreign non-main proceeding just because the debtor has assets somewhere else. To tell the truth, I don't know whether this is going to be a good thing or a bad thing, but it makes it much more easier to recognize several different non-main proceedings throughout the world. According to the model law, establishment means any place of operations where the debtor carries out a non-transitory economic activity with human means and goods or services. This is much more comprehensive than only having assets in a specific jurisdiction. Another specifics of our model law as incorporated in Brazil is the anti-coming manipulation provision. It's in section 167J, and it says that the court may recognize a foreign proceeding as a non-main proceeding if it concludes that the coming was shifted to another jurisdiction or manipulated somehow in order to allow the debtor to file the main proceeding in a different jurisdiction. I believe this grants the Brazilian courts a great power against foreign shopping, and if used wisely and correctly, I think it's going to be a good thing. And finally, I'd like to refer to our section 167N, number 5, which grant broad powers to local courts regarding the available relief. It says that by recognizing a foreign main or no-main proceeding, the court may grant any other relief that may be necessary to protect the debtor's assets in the interest of creditors. This is, again, a very important provision, giving even more latitude for local courts to try to achieve the goals of the model law. So, Olya, this is a general overview of the framework, the new framework, and some specifics of our bankruptcy law, our model law incorporated by our bankruptcy law.
Yeah, thank you very much for that. So since this reform, have you seen more companies seeking recognition of the foreign insolvency proceedings in Brazil?
To be honest, as far as I know, and as of today, you only had one inbound case seeking recognition of 2 foreign insolvency proceedings filed in Singapore. The ProSafe case was the first case, and only that I know, that applied the new cross-border rules on insolvency proceeding. We cannot deny for sure that was a good example that our courts in Brazil will take cross-border rules really seriously, and also that it achieved some of the goals of the model law. The best part, in my view, for practitioners that haven't seen like recognition of foreign insolvency proceedings was that the courts really granted direct access to a foreign representative to request the recognition of the 2 proceedings files in Singapore. We could also see, and could you please go to the last slide, please? See that the new rules indeed made it possible to achieve one of the model law goals, which is having a simple and expedite proceeding for recognition of foreign insolvency proceedings. If we take a look at the timeline there, we can see that from proper filing, since the filing had to be amendment some days after its filing, from the first order, the preliminary injunction protecting the debtor's assets it took only 5 days. And from the filing, the proper filing, to the full force and effect, recognizing the scheme of arrangement in Singapore, it took only 5 months. So it was really expedite and efficient process in Brazil. But if we take a careful look in the details of the case, we can see that our courts still have a lot to learn from other jurisdictions with longer experience in cross-border cases. This case, the ProSafe case, was not challenged or contested in any way, and maybe because of that, it was so fast, and actually the decisions, the rulings on the COMI especially were so poor, so short, as we're going to see. In Brazil, as in other countries, when you adopt the model law on cross-border insolvency, the court has to decide whether to recognize the foreign proceeding as a foreign main or no-main proceeding, and this is because the effects are different. If a court in Brazil recognizes the foreign insolvency proceeding as a foreign main proceeding, it triggers automatic mandatory effects, what does not happen if the court recognizes the foreign proceeding as a non-main proceeding. Can you go to the second slide, please, now? But even with the other one, the second. Yes, even with the importance of the COMI analysis, in the first ProSafe ruling case, the COMI analysis was limited to 2 paragraphs only. The court referred to this corporate chart and mentioned that ProSafe SC, which was the debtor filing the scheme of arrangement in Singapore, was a parent company located in Norway, with headquarters in Norway, that it controlled directly and indirectly several other companies, 5 of them with headquarters in Singapore, and because of that, based only on that facts and without any other piece of evidence, concluded that most of the contracts of this group were executed in Singapore, and that was a place where creditors believed the company was located. And then this COMI analysis was concluded saying that the COMI for the ProSafe SC and for the ProSafe group as a whole was in Singapore. In the second ruling for ProSafe Rigs Limited, the COMI analysis took only 1 paragraph. The court recognized the filing in Singapore as a main proceeding only because the ProSafe Rigs Limited was headquartered in Singapore. Can you go to the next slide, please? Apart from being really shallow in the discussion of COMI, which is really important for foreign recognition of insolvency proceedings, the relief granted was even broader than it was supposed to be. And this is because the court issued an injunction protecting the debtor assets against attacks of creditors. And among those assets were 3 vessels that were located in Brazil, but one of those vessels was not an asset of any of the debtors of the claimants in Singapore. So if you take a careful look on these decisions, we can realize that the COMI analysis was not made on a pure entity-by-entity analysis, but was a group one, which is somehow contrary to the model law guide on enterprise companies. But since COMI is a total new concept in Brazil, and determining the debtor's COMI is one of the most important steps in cross-border insolvency, we should have a consistent interpretation of such concept. And in order to do so, we need not only to look to the UNCITRAL guides on the model law, but also to learn a lot from countries who have longer experience with those rules, like the United States. Thank you, Olya.
So, based on the current cross-border insolvency framework in Brazil, do you see that there's a fit or particular need to adopt the Judgements model law? What is the future there?
Yeah, my impression, Olya, is that our legislator is not interested in adopting the model law on insolvency-related judgments, and this is because it included paragraph 6 in section 167A, which says that when applying the model law, whenever applicable, courts shall respect the exclusive jurisdiction of the Superior Court of Justice to confirm foreign judgments within the Brazilian territory and to grant the exequatur to rogatory letters. We do have in Brazil a very simplified proceeding for recognition and enforcement of foreign judgments, and I don't see the procedural rules as a problem. The problem rests, in my view, in the exclusive jurisdiction of the Superior Court of Justice. This is the highest court for non-constitutional matters, and it's overloaded with cases from all of the states of a giant country like Brazil. So sometimes a recognition case may take long, but not because of the rules themselves, because of the Superior Court of Justice is overloaded with work. So in order for us to incorporate the model law on insolvency-related judgments, I'm sure we'd first need to amend our constitution, because this exclusive jurisdiction of the Superior Court of Justice has a constitutional base. So unfortunately, I don't see it happening sooner than later. That's it. Thank you.
I think we have just a few more minutes. So Katharina and Dario, what is your view on the situation where a jurisdiction already has adopted the MLCBI, but wishes to adopt the judgment model law? Is there a certain level of harmonization that would be required? If you could guys take this in turn, maybe Dario was...
Well, I will say that based upon the interpretation we have had in actual cases, in case law in Mexico, it is desirable to supplement, to complement the model law on cross-border insolvency with consolidation of the proper safeguards and grounds for denial or rejection of insolvency-related judgments. That will make the regime most clear and efficient. But this is desirable. We think that it will not take place because insolvency is not a main concern of the legislators in Mexico. Actually, we need to make some adjustment to the current model law on cross-border insolvency, our Title 12. But we can live with it. And I would say something that may underline our view, that it is very different having now the model law than before we didn't have. It's much more better. And if we had the two other model laws on insolvency judgments and group of companies insolvency, it will be much more better for the insolvency system.
I agree. I think, Rodrigo, in your panel before, you had a slide with kind of fluid borders, because if you create multiple tools, you create the risk of overlap, which you highlighted. Now, from my perspective, I don't mind overlap. Overlap means I choose what suits my particular circumstances best. If I need recognition of, as Dario calls it, the umbrella proceeding, I can throw in an application for a specific insolvency-related judgment, procedurally easy, do it all in one go. If I don't need that, or I come from a country where actually it wouldn't be recognized because it's not a COMI or establishment country, I use the other model law. So overlap is difficult, but insolvency is already a niche sport. And in my jurisdiction, I've already got overlap. I've got other tools apart from the model law that I can use. Overlap does give options, and options can be beneficial, even though complicated, because it could drive my choice, which could drive cost implications. So harmonization versus overlap, I don't necessarily need to harmonize everything, because overlap might not be a bad thing, but you need to look at it very carefully.
I just want to underline that it is not overlapping. It is to have, as an insolvency regime on cross-border insolvency, the option to go for recognition of the insolvency proceeding as an umbrella or the individual insolvency judgment. It depends. It will be under the circumstances of the case and see and make reference to the cost and time efficiency. Because these cases, as Robert Van Galen described before, may take many years. And what we need is time and cost, efficiency. And if we have the ground in our legal regime, then we may accomplish the targets of the insolvency purposes.
Thank you. Do we have any questions from the audience to the panelists?
More than a question, maybe it's a comment, but I would love to know what you think about that. Optionality is great, but
shall I have a go, Phoebe? If a country had both options, and I've got an insolvency-related judgment, then it would be my choice whether to try and get it recognised under the original model law or the judgment model law. But I would know that they are both avenues, so that does give some certainty that they are, it might give you more certainty because there's different ways of getting at the ultimate goal. So you might not be able to say this is the path, but having more avenues might give you more certainty to get to the end path. More of our coffee?
Federica, I will say that there will be no uncertainty. On the contrary, that will improve the avenues, the legal tools, the mechanism to reach recognition and enforcement.
But can also be just the opposite, right? It depends on who is using the tool, who is using the optionality.
Well, that's why I think that both those complement each other. If we have the provisions of the model on cross-border insolvency complemented with the specific provisions of the recognition and enforcement of insolvency judgments, we make a united system that will work. It will make and provide more certainty, efficiency, and cost and time efficient, I think.
Thank you very much again, and I see Evan is ready to conclude. So.
No, just briefly, I wanted to thank everybody for their participation, all the panels. Just a few announcements for those attending the reception upstairs. There'll be 2 elevators on both sides when you walk out. The court staff will be here to assist with directions. And again, I want to thank the court staff for all of their hard work in helping us put this together, as well as the UN Secretariat. It's truly appreciated, and I hope you find it a very informative conference. Thank you.
Yes, Dario, very good.
My friend Sergio,
Some of these are still
oh,
on.
my pleasure.
Somebody might turn them off.
Congrats, and we're always happy to have the English speakers in our panels to help us from Latin America.
Nice to meet you.
Olya, thank you very much. Sam, please, you made a very good job.